That's what you're doing. Don't we already know what a constitution is? I mean, you look around, there's a lot of constitutions around. And we have the Australian constitution, we have the constitutions of the states. So, kind of like, aren't you wasting your time and money of the university in doing that? And so the sort of imposter syndrome came into me, and I was like, oh my God, what am I doing it with my life? Should I really be doing this? And I decided to answer the question differently now. So every time someone asks me, what is your PhD on? I answer, well, I'm doing an ontological investigation on the constitutions from a legal normative perspective or using this jurisprudential viewpoint. And then someone just goes like, oh wow, yeah, okay, that seems valuable, right? But it is only one simple question, but sometimes the simple questions don't have simple answers. Right? And sometimes we think that we know what a constitution is, but just by the fact that we have this question here, what is a pseudo-constitution? We start to wonder, okay, but do we actually know what the original is? Because look, we have one premise here, right? So if I'm talking about a pseudo-constitution, that means that there is a genuine constitution, right? So if I say that a particular coin that I received in exchange is a fake, this is a fake coin, it's because I know the original, right? The Louis Vuitton bag is a fake bag because there's an original bag that is the real. It has certain qualities, it has certain manufacturing features that make it the original, right? So when we say a pseudo-constitution exists, then we have to ask, what is the genuine thing? What's the real thing, right? So this is the first premise. So I have two premises that I would like to present because this is basically an overview of my thesis, and I'll present to you, of course, what is a constitution in the end, but to get there, I think we have to agree on certain things. And I'm here presenting these two premises. The first one then is, well, there must be this genuine constitution. Now, how do we find what the genuine constitution is? How can we identify the genuine constitution? And I think there are two major approaches to that. The first one, I'm calling it the lowest common denominator, which is trying to identify what are the features of constitutions. So let's look at all constitutions in the world. Let's try to identify what are the elements that they have in common, right? And then we'll narrow it down to those particular elements that all constitutions have, and then we can maybe come up with a definition of a constitution based on those elements. And so we can look at constitutions and say, oh, maybe democracy is here. Judicial review, okay, yeah, separation of powers. So these may be entrenched human rights. We'll start looking at these elements and the form of constitutions, how they are composed. We'll try to identify. So what makes a constitution a genuine constitution? Stop looking at it. There's an issue with that, and I'll show you in a second. And that's why I don't particularly adopt the lowest common denominator. Because the problem is that pseudo-constitutions and genuine constitutions, they have sometimes, and most of the time, the same elements. If we only look at the elements, we'll see that sometimes a liberal constitution can either be genuine or pseudo. If they have entrenched human rights or not, they can be pseudo or genuine. So the elements don't really tell me what I'm trying to identify here. The elements themselves of constitutions, having a strict separation of powers or not having separation of powers at all, having judicial review or not, don't really give me what I need in order to identify the difference, the distinction of the two types of constitutions. So I think that one of the defects, one of the flaws of contemporary, the majority of contemporary constitutional scholars, is that we are focusing too much on the elements and discussing too much the elements of constitutions, when we should be taking another approach. I think we should take a step back, and I do say that I think we have to adopt this legal normative perspective. We have to stop looking at constitutions only as they are, and we should start looking at what they ought to be as well. And so this avoids the naturalistic fallacy of Hume's law. You might have heard of that, which does not derive oughts from ises, but then we think of what the ideal is, what we should pursue, and from there we try to identify the instances here, what the thing actually is. And this is why I adopt the central case method. Central case method is just this expression I'm taking from John Finney's philosophy, because it mentions the central case, but it's actually Aristotelian, because Aristotle calls it the focal meaning of a thing. To identify the focal meaning, what the thing actually is, what the thing truly is, we have to look at the thing's ends, and from the ends we can identify its functions. When we understand the functions, we can identify the actions of the thing, and then we understand its nature. And so if I'm trying to identify the nature of constitutions, so I'm trying to identify what a constitution really is, then I have to look at the ends. I have to look in this teleological sort of approach. And this is what I'm proposing here. So one of the premises that in this lecture to understand the pseudo-constitution is that we have to look at the genuine constitution. We have to identify, understand what it is. And to do that, I propose we use the central case method. And why I think the lowest common denominator is not the best option? Well, because there was an attempt before by Carl Lowenstein. Carl Lowenstein, you can see him there, looks like a very fun man, and he proposed this ontological classification of constitutions. And he said, we can identify the nature of constitutions by trying to identify these two elements. And look at the elements. He said, well, the elements are legal validity and social value. So validity and value. Now, if you've remembered, or if you ever studied someone called Hans Kelsen, you might have heard of these two elements here. So Hans Kelsen was, he had two elements in his philosophy of law as well. He said, well, law is composed of this particular element of validity. The law has to be validly enacted, it has to be promulgated according to the rules, etc. But it must also have efficacy. So Kelsen used the word efficacy, but Lowenstein, not to copy it, tried to put value, so social value. But it's the same idea here. And so for him then, he said, we have three kinds of constitutions, according to their nature and taking these two elements. We have the normative constitution, which is legally valid. It was promulgated, enacted according to the laws, and society accepts it and uses it as a norm to dictate their life, to direct their life. So it is a law that was legally valid and it has efficacy. It is people in society comply with that law, they follow that law. So this is a normative constitution. This is the ideal constitution. But then he said, well, but sometimes we have nominal constitutions. Constitutions that have the name of constitutions, but they don't really operate well as society. So they are legally valid. They were enacted according to the rules. There was a convention and constitutional assembly. People agreed to that law and they made it a paramount law of the legal system, according to which all other laws will follow and will follow its validity. But either because society was not prepared for it, or because somehow this was an aspiration of the people. They wanted that constitution, but society somehow has some external elements and factors that prevent that constitution from having efficacy. We can't call it a normative constitution. So it has legal validity but no social value. And he called it nominal constitution. And then he said there's a third type of constitution. And look at this. He said there's the semantic constitution. The semantic constitution is the negative sense of the word semantics, right? So he's saying, look, the constitution was legally valid. It is legally enacted, follows all the procedures. It is efficacious because people actually follow that rule. However, it's not a constitution at all. So if you're doing a typology of constitutions, this is terrible, isn't it? Because now you have two elements, and the semantic constitution is the same thing as the normative constitution in terms of its elements, right? So what's the difference here? What differentiates normative constitutions from semantic constitutions? And Lowenstein answers that by saying, well, the fact is that the semantic constitution is but an instrument for the perpetuation of power. the political ruler, the political holder, he calls it the power holder, has enacted that constitution so that they can maintain their power. They pay lip service to what the community is doing or wants, but they actually enforce the constitution. It's valid, it's efficacious, but it doesn't somehow fit a particular purpose. But this purpose and this idea of a constitution that is used only instrumentally does not fit the framework and the matrix that they developed here, right? So what is missing, and that's why I prefer the central gate, is exactly an acknowledgement of the purposes of the constitution. What are constitutions for? But then if we add a third element here, then we have to change this, because then the whole thing here will actually find some other instances of constitutions, different types of constitutions. And so the second premise that I would like to present to you is that constitutions have this double life. And I want to explain what that is. Double life means that constitutions have this factual life, so they exist. Constitutions are paramount law. They, as Kelsen has said, they inform the validity of the other laws that are hierarchically inferior to it, right? So constitutions exist. They exist as obligation-imposing rules. There are secondary rules, and by saying that, you will remember Hart, right? So Hart is saying these are rules of obligation, secondary rules of obligation. So there's this factual life. It is an empirical reality, right? They have that sense, but that's not all. And even Hart himself, a legal positivist as he was, like the best one probably, he acknowledges that there must be, the laws are not only empirical realities, social facts, but also reasons for action, right? He said that they are reasons for action. They are accepted rules. There's a critical reflexive attitude. I don't know if you remember that from Juris, but he says there's this acceptance, an internal viewpoint of acceptance in the participants that use the legal system and the laws. But he doesn't say how these reasons are justified or why they accept that. Actually, he does. He says, oh, it's because of survival. Let's not go there. There's a minimum content of natural law. Doesn't matter. Let's move forward. Right? He rejects a Kantian and a Humean sort of approach. He says, yes, there is this normative thing, but doesn't really matter. Let's move forward. What matters is the empirical reality. But then I'm saying, well, it does matter, because we have to understand what things are for so that we can understand what they actually are in the central case, right? So I'm taking that from Hart and saying, so what is this normativity? What is this normative life? What are constitutions for? Because we understand that they have this empirical reality. But now, what are they for? Why do they exist? Why do we accept the Constitution as a constitution? And so we have the factual life, that constitutions exist as paramount law in a legal system, which is accepted by participants, and they are obligation-imposing secondary rules. But we also have this normative life. The normative life tells us of the ends, the telos, teleological brain, the finish, the ends, the objectives, the purposes of the Constitution. And these purposes direct this legal system towards what I call public justice. Now, I can't really explain full on here what I mean by public justice, but the idea, the core idea, is that justice, if you go outside and you walk through these doors, the last phrase that is carved in the top of the entrance here in the law school says, "Sum quid tribuere," which is to give each person their due. And that's the core idea of justice, right? To give each person their due according to their interests. And you have the idea of retribution, or sometimes tribution, giving something that is due to the person, or giving back something according to what they do in the correct measure, etc. That's the idea of retribution, of justice, of this idea of giving each one their due. And public here means this space in society where the interests of the individuals, of private associations, and of governmental associations, they interact. So it's the public arena, sort of. Okay, and this is the idea. So the Constitution is aimed at promoting justice in this environment. That's the idea behind it. But now, these are not separate lives. They don't exist independently of each other. So the genuine Constitution must somehow unite. They intersect and they are interwoven, right? So they exist together. And the thing that does that, if we think of the factual life as what the Constitution is, we think of the normative life as why the Constitution exists, then constitutionalism is the how. It's the conciliation between these two lives. It's the link between them. Constitutionalism is this idea that at the same time that we are empowering the governments, we're empowering the institutions, we are giving them and establishing them, creating them. At the same time, we're also doing that towards justice, to give each their due. Not only the whim of the political powerful, not only the whim of a particular party or a minority or a majority, but to give each one their due. So constitutionalism makes the link between these two lives. And so with this, we have a genuine constitution. A genuine constitution is a constitution that has a factual life. It is paramount law. It exists. It establishes institutions. It establishes the government. It gives these institutions powers and procedures, etc. But then it exists so that we can have an appropriate amount of retribution to each individual in their interests and in the multiple interests that they hold. And we do that through constitutionalism. So the link between the two is using constitutions. So now I think we are positioned to understand what a pseudo-constitution is, because now we know what the real thing is. And so pseudo-constitutions, they are this watered down, deviant, corrupted, fake, qualified versions, peripheral versions of the genuine constitution. They can't be the thing, but they somehow fail in one of these elements of the genuine constitution. They either don't have factual life, and then maybe they are just principles of justice, not a real constitution, or something like that. The idea of constitutionalism, not a real constitution. Maybe they don't inform the validity of the other laws, because constitution should do that. Maybe they're failing the normative life. They don't pursue justice at all. They don't seek to implement public justice at all. Or maybe they're doing something else, some other goal, some other purpose, but not public justice. And therefore they're failing that second element. Or constitutionalism. Maybe society is not ready, there's no conciliation between the two, and therefore it fails as a genuine constitution. And so the term pseudo-constitution comes as this umbrella term that encompasses all kinds and types of different varieties of constitutions that somehow fail one of these elements. So it's not, sometimes they're called sham constitutions, sometimes they're called constitutions without constitutionalism. I've seen illiberal constitutions, I've seen undemocratic constitutions, unconstitutional constitutions, all kinds of constitutions. I mean, you can name it, right? So what I've tried to do is, since I know what the general constitution is, how can I then create a typology that respects that? And it's encompassing its idea of pseudo-constitutions, but still identifies different instantiations of these types of pseudo-constitutions. And so it's the first time I'm showing this. So first time, yes. Well, only 3 people, me and 3 other people, seen this before. So yay, yes. I'm very happy to receive feedback on it as well. But this is basically what I've developed, right? We have then 3 types of pseudo-constitutions. And each type of pseudo-constitution actually has 2 types of species. So 2 species in each one of them. So the first one would be a counterfeit constitution. And this is generally what we call sham constitutions, fake constitutions. So the counterfeit constitution, it exists in practical reality. It exists as a constitution that is paramount in the legal system, that somehow imposes rules and corrects the vices and the issues that the primary rules have, so less rules of change, less rules of recognition, but they don't aim at public justice, and because of that, or somehow, they are unable to connect the two lives. So the constitutions are created to be this higher constitution that's sitting at the apex of the legal system, but it doesn't care really about giving each one their due. Right? And so the counterfeit constitution has maybe two instances. A deceitful constitution, which is intentionally created to do that, for the perpetuation of power, or a misjudgment constitution. A constitution that aims at something else. Maybe religious uniformity or ethnic integration, right? So maybe some real purposes that are good, and constitutions could do that too, but they are not the primary aim of constitutions. And they substitute that they have a misjudgment on what the actual end of constitution is. Because they do that, they're failing the normative life. And so they don't have this connection between the normative and the factual life. And so we have the counterfeit constitutions. The other type of constitution is the fortuitous constitution, which, as you can see there, what happens is they don't aim at public justice, so the normative life is failing, but somehow they still implement public justice. So they are either accidental, because somehow it happened, and I honestly don't have an example of that yet, but I'm happy if anyone has.
Australia?
No, Australia would be something else, but yes.
They fail the normative life.
Yeah, well, maybe. The other one would be the replica constitution. So another kind of fortuitous constitution would be a replica. They're doing what we call constitutional transplants. They're copying the genuine constitution, copying provisions of other constitutions, implementing them in society, which is not the ultimate aim of the new constitution that has been created to achieve public justice, but somehow they end up doing it. They end up giving and retributing to each person their due, or to the best extent possible. That's something that I should have said as well. And then we also have the defective constitution. And this constitution is a kind of constitution that, well, it exists in practical reality. It aims at public justice. It really wants to achieve justice, but then somehow it fails in that mission. And so I think this is more comparable to the nominal constitution that Karl Marx had devised. The idea is that maybe because society is not ready, or because even though it is ready, there are some external factors that prevent the constitution from actually having that particular efficacy. Somehow the constitutions fail, and they can't be genuine, even though they are aiming at public justice. So what is a pseudo-constitution? Well, pseudo-constitutions are all kinds of constitutions that somehow fail the genuine constitution, that they are missing something in one of these elements that involve the double life of constitution and the conciliation between the two, which is constitutionalism. And so we can identify them by knowing what the actual thing is. And that's basically, in a nutshell, what I'm trying to do with my piece. So I'm happy to take questions and try to respond to them as you go. Okay.